All right. It looks like we are live. Hello and welcome back to yet another Beehive live stream. Today we have an update in the Lauren the Mortician and Jeanette Braun lawsuit where they're suing several TikTokers for basically speaking their mind about Lauren the Mortician and Jeanette Braun, mostly Jeanette Braun. And so where we left off before is that the Jeanette Braun and Lauren the Mortician filed a lawsuit against these four TikTokers, and then the four TikTokers filed a motion to dismiss, and then Jeanette Braun and Lauren the Mortician did a amended complaint, first amended complaint, and then the other TikTokers then filed another motion to strike, a motion to dismiss back at them, and now we are in the spot where Lauren the Mortician and Jeanette Braun are responding to these motion to dismiss, basically saying that the case should not be kicked out of the court. Now, if you guys have been keeping up with this case on this channel, a lot has been going on, in this motion to dismiss, or this motion to deny the motions to dismiss, are absolutely, it is absolutely brutal. It's super long, so I'm going to try to bounce around in it so that we can kind of remind ourselves about what's going on in the lawsuit, and then we will try to figure out what is Jeanette Braun and Lauren the Mortician's reaction to this. I've tried to read this motion, and it's a bit like, although they tried to be like really organized, it still feels disorganized to me, if that makes sense. And I wonder if you guys will feel the same once we get into that case. There has also been some other news popping up, but I haven't had too much time to look into it, given I was at work and then trying to read this monstrosity, this crazy response to the motion to dismiss. I haven't had time to catch up with it. Like Beyonce is being sued for copyright infringement. We got Sean Kingston in trouble for basically defrauding people, along with his mother. We got Kelly Clarkson apparently settling the lawsuit against her husband. I haven't looked much into that. I see what's going on. We got, Angelina Jolie needing to disclose her NDA so that they can determine what to do with the winery. It's just a lot going on over this weekend, but we're not covering that today. We are going to get back into the drama of Jeanette Braun and Lauren the Mortician suing the TikTokers, Rebecca Day, Casey, and also Lily Martin and Jessica Vasquez. So we are going to talk about that today. And without further ado, I am rambling. Let's see where we're at with the like goal. We are at 8 likes with 13 people watching live. So I know there's some people here that have not hit the like button. So if you haven't hit the like button, please do. It does help us out in the algorithm, and it helps us get more friends here in the Beehive. And we're going to go ahead and set our like goal for the stream at 50 likes for the stream. So let's see if we can get that number up. Oh, there we go. We got 1 like coming in. So everybody else who haven't hit the like button, go ahead. And we are going to go ahead and jump into the chat to see who is watching live. So if you haven't put anything in the chat yet, make sure you do so that we can say hello. And we are going to have Bossy B bring us in so that we can say hi to the chat. All right, y'all. And we had our members live stream over the weekend. That was super fun. So thank you everyone that joined me live on the members live stream, which was mostly Kimmy. And then we had one other person join in on with us. But it's definitely slipping my mind right now with the long weekend and then getting back thrown into class. Cheryl, yes, Cheryl did join us. That's who joined us. I was like, man, the name is slipping me. Thank you, Kimmy, for that. Okay, so let's say hello to everyone in the chat. We got Super Serena 808, member of the channel. Welcome in, saying aloha, hello, and welcome into the live stream. Nice to have you back tonight. We got Ohio Palm Mom, another member of the channel. Hello, welcome back. Giving a pink waving hand. Nice to have you back. We got Miss Frosty, another member of the channel, saying good evening, everyone. Hello, and welcome into the live stream. Nice to have you back tonight. We got Just Me MD, another member of the channel. Welcome back. Saying hi, everyone. Hello, and welcome back. I just keep saying welcome back. I got to come up with some cooler things to say when welcoming people back to the live stream. Okay, we got Phoenix Waller, another member of the channel. Welcome in, saying I can never decide which is crazier, the two between Janet and Lauren or Illuminati. Oh, we were supposed to get into the Illuminati case, and I just like abandoned ship on that one. So I don't know everything that's going on with that one, but if I'm not mistaken, they're like on their last amended complaint, and the case is pretty much over at this point. But I could be wrong because I never really kept up with it. So If you know about the Illuminati case, go ahead and feel free to drop it in the chat. But this Jeanette Braun and Janet, let's not get ourselves in trouble, and Lauren the Mortician case, it's absolutely crazy. Like I said, the motion to dismiss, or the response to the motion to dismiss and motions to strike, I thought was going to be like organized. It seemed organized in the outline. And then as I started to read it, I was like, what are we doing here? Where are we at here? But we'll see if it's a little bit easier to understand once I'm reading it out loud and not on my iPad while the TV is playing in the background. It might be me. It might be me. But welcome in, Phoenix Waller. Nice to have you in tonight. We got Amy Evans. Hello, welcome back. Another member of the channel saying hi, guys. Hello. Chelsea B saying hey, everyone. Another member of the channel. Welcome in. Hello to you as well. We got Kimmy Locker saying hello, everyone. Our member, our moderator, our consultant, our paralegal of the channel. Hello and welcome back in. And also thank you for grabbing the documents. I know I was all over the place this morning. I sent Kimmy like I don't even know how many cases I sent to you. And then she was like, Lauren the Mortician has something new. I was like, yeah, that works. It was like 8 cases. And it was like, yeah, but we should cover that. And then we'll come back to all the other stuff because this channel likes the Lauren the Mortician stuff. So we're going to talk about it. We got Smalls dropping a heart and, a solid sign. Hello and welcome back in, Smalls, moderator of the channel. Nice to have you back in tonight. We got Just Me MD saying buzzing in and sending love from East Texas where the weather is bipolar and the pollen be popping. Yes, we missed that line last time. Texas has been in a bad mood last few days. 1 minute she's throwing tornadoes and then the sun shining, just all over the place, right? We all have our days. And Texas is having a day of her own. Small says to Phoenix Waller, Janet Lauren, Def Wilder, in my opinion. On the cases. Phoenix Waller says to Smalls, I don't know, trying to take Oz's house was pretty big. I haven't kept up with that case like that, so I don't know like everything you guys are talking about. Kimmy Locker says he doesn't even use a consistent format for the whole thing, which drove me nuts. I'm like, maybe it's because the TV is playing and I'm like reading it on my iPad, but I'm like, no, like I literally always do that before the stream. But this one, I was just like, it seemed like it was going to be so organized, Kimmy. It did. Small says to Phoenix Waller, nothing trumps the bad faith wellness check for me, but bias due to trauma. So I def hear you. Oh, I forgot about that in the Lauren the Mortician case. They did send the false little welfare check onto KC, which we're going to talk about some stuff with KC too. I didn't download all the documents, Kimmy. I only did the response to the motion because that is just so long. So we'll summarize the other documents. We got SoCo SLP. Hello, welcome back in, saying, looking at the thumbnail, I think Lauren and Janet are actually the same person, multiple personalities, just changed their hair color. Phoenix Wallace says to Smalls, either way, all these ladies be wilding at this point, right? Let's just put them all in the same bucket. Smalls says to Phoenix, Waller, Def, you ain't wrong about that, right? Just put them on the equal. Let me not say nothing crazy because then I might be next. Ohio Palm Mom says, I wonder if Janet wrote some of it. I mean, her lawsuit to me, when we read the one, I think we still have one more, right, Kimmy? It seemed very well put together. So I don't even want to blame Jeanette Braun on this one. Like, they said she hired her friend as an attorney, so maybe this person is just kind of new to the game, but I don't know. I'm not willing to blame Janet on this one. So, which apparently calling her Janet is offensive as well. So we'll figure it out. Anyways, we are talking about Jeanette Braun along with her law firm, Braun IP Law LLC, and Lauren Propson, also known as Lauren the Mortician, which I will have to say, ever since this lawsuit was filed, I do not see Lauren the Mortician on my For You page. And she used to pop up occasionally for me. Since the drama started, it was a little bit more sparse. I actually liked some of her content. I thought it was interesting. But now I would say that this lawsuit has been filed, and maybe it's because I don't follow her, but I haven't seen much of her content popping up on my For You page on TikTok, and I do blindly scroll that thing probably more than I should. They are suing Rebecca Day Kneebox, Casey, the owner and operator of the online social media account Caffeinated Kitty, Lily Martin, and Jessica Vasquez. Now, what was interesting to me that it just like never caught on to me. Like I never caught on to it. Like I noticed they were calling her by her social media handle, but it never really like clicked to me that they are continuing to call her by her social media handle. And this case has been going on for like 4 months now. Like y'all haven't figured out that girl's name yet. Like what's going on? And so there was a minute order released by the court saying, y'all need to name this lady. This lady is represented by counsel. You should be able to figure out her name. And if we are not using her name, why? Why are we protecting her identity? And why are we not using her name? I don't know if she has some other stuff going on in her background. I know there was something, I think, with Jessica, where she had a kind of like a stalker situation and they didn't want to put where she actually lived. But I'm like, okay, well, now the world knows where Jessica lives, but we still don't know Casey's name. So if anyone knows why they are hiding Casey's name, please feel free to drop it in the chat. I think eventually after this minute order was released that they're going to go ahead and release her name, because I can't think of a reason why her as an adult would have a private name unless she's like under witness protection. But if she's under witness protection, why would she then be on, social media gaining a huge platform? So I don't know. Let me know if y'all know. Let me go ahead and jump into, I need to do a bossy B so that we can actually jump into the case. So other than the minute order trying to figure out if we're going to ever get Caffeinated Kitty's actual name, if we're going to get it at some point and put it on the document, the court's basically like, it needs to be in the caption of every lawsuit. So now that she's represented by an attorney, get her name on this document unless there is some reason why her name should be protected. I can't think of a reason. Like I said, let me know if y'all can think of a reason why her name should be protected. Okay. And then we move on. There was a motion filed by Lauren the Mortician and Jeanette Braun asking the court if they could have more pages for their response in their motion to dismiss, because they basically didn't want to repeat the same facts over and over. But then when you read it, they're still repeating the same facts over and over. So literally all they would have had to do was copy and paste like the initial legal part of it, and then give the facts that arise out of those defendants. But instead of doing that and following them in all different motions, they were basically like, oh, well, it's only going to be 5 more pages than if we just responded to them separately, each of them separately, because we would get 15 pages per person we need to respond to. And so they just decided to put it all together and do 50 pages, which I don't really like for them. I think it does make it a little bit confusing. Even on this channel, when we covered the motion to dismiss, we did not cover all the motion to dismiss because they're probably going to say something along the similar lines, right? I believe they all have the same attorney, if I'm not mistaken. But yes, they're going to say something of the similar lines, but we can actually keep it like stuck to one person, right? This one goes, okay, we're going to talk about Kitty, and then we're going to talk about Lauren and Kitty, and then we're going to talk about Jeanette and Kitty, and then we're going to talk about Rebecca Day with Jeanette, and then we're going to do this, and then we're going to go all the way back and we're going to start again with Kitty, and then we're going to talk about this with Kitty and that. And I was just like, no, I don't like it. I'm confused. So let's go ahead and jump into it. This is Jeanette Braun's and Lauren the Mortician's response to the defendants on their motions to strike and motion to dismiss. Y'all, I'm probably going to like skip around a lot in this one because, like I said, it's long. It's 54 pages. Some of it, of course, is cited into like case law and things like that, but it is a very, very long complaint. And we're not trying to be here all night. Like, I know we like the drama with Lauren the Mortician and all, but we're not going to be here all night reading it. That's for sure. So let me go ahead and share the screen. We got the plaintiff's memorandum of law in opposition to defendants' motions to strike and defendants' motions to dismiss. And now we're talking about motions to strike and motion to dismiss. So not only do you have 2 separate type of motions, but then you're talking about 4 different defendants, and not all of them are being sued for the same reason. I don't think that they give rise to the same facts, maybe the same legal standards that we need to discuss, but definitely not the rise to the same facts, because they all said something different. Could they have been defending each other? Sure. But at the same time, they're all saying something different. So I honestly don't think that this needed to be all in one document. Let's see here. We're going to just skip the introduction. all the little different bullet points and made me think this was going to be super, super in order and I was going to be able to follow it so good because the table of contents, it looks superb. But I didn't even notice when Kimmy said they didn't even use the same format throughout the document. So here we go. Let's reintroduce ourselves to what's going on here. Defendant's separate motion to strike and motion to dismiss should be denied because plaintiff have pled sufficient facts to establish their causes of action, and defendant's anti-SLAPP argument relies on disputed facts that require discovery and cannot be resolved at the pleading stage. Plaintiffs have established sufficient facts to support their claims in the First Amendment complaint. Specifically, defendant Casey, Vasquez, and Martin anti-SLAPP arguments all rely on whether Jeanette Braun and Lauren Mortician are public figures, whether the audience of defendant's statement would interpret such statements as opinions or speculations rather than factual claims, and whether defendant Casey's statements about plaintiff Propson being transphobic were a matter of public concern. In addition, regarding to the legal sufficiency of plaintiff's claim, plaintiffs each state sufficient facts to establish their claims for defamation per se, false trade libel, tortious interference with contract, tortious interference with existing and prospective business relationships, and intentional infliction of emotional distress. Because defendant's motion raised the same legal issues and are generally the same. No, they raise the same legal issues and are generally the same. Then why didn't you just sue one person? Why'd you have to sue everyone? They're the same claims. Can't you just make an example out of one person? No, you can't just say, oh, basically what we're suing them for is like the same stuff, but court figure it out. Plaintiffs address and oppose our arguments set forth in each defendant's pending motion in the memorandum of law. Due to the disputed factual issues in the defendant's anti-SLAPP motion, and because plaintiffs pled sufficient facts to establish their claims, this court should deny defendant's motion to strike and motions to strike and motion to dismiss. So here we are. Same legal issues and basically the same allegations against each person. I don't agree with that. They all did say similar. There were things that were similar about what was being said, but I don't think that they are generally the same. Okay. And like I said, I think it makes it very confusing to go through 4 different defendants, or 2 of them are actually paired together because they were on a show together. And so maybe that one makes sense to stick together because that's how the defendants have been filing it. But to add all the additional ones into it, I'm just not in agreement with it. But y'all can let me know if you think differently. There was something I wanted to talk about on this one too, and I forgot what it was. The fact that they're now questioning whether they are public figures. That one stood out to me because the First Amendment complaint basically alluded to them being public figures with amassing 2 million followers and they're so popular. Now they're bringing it up as an issue when this has never been an issue before. So I don't think this is whether Jeanette Braun and Lauren the Mortician are public figures are really before the court, because in the First Amendment complaint, they basically established that they were public figures, but now they're trying to backtrack and say, wait, maybe they watch Ian or maybe they watched us, but maybe we're not public figures, right? Which I know for a fact that it says it, because I was like, I'm surprised that they're saying that they're public figures just by being TikTok personalities on the internet. So now they're backtracking and saying, well, we have to figure out if we're actually even public figures, although we're pleading actual malice. It just makes no sense to me. But let's go ahead and jump back into it. The background of the case, just to kind of give us a reminder of what was said. The present case arises from the series of defamatory statements made by defendants which significantly damage the professional reputation and business interests of plaintiff Jeanette Braun, Braun IP, and Lauren Propson. Plaintiff Braun, an attorney and owner of Braun IP Law LLC, alleges that defendants made multiple false and defamatory statements across various social media platforms, accusing her of unethical behavior, filing false copyright claims, and committing perjury. They also called you a rogue attorney. Plaintiff Propson and social media content creators alleges that defendant Casey falsely labeled her as transphobic, leading to severe reputational harm and loss of business opportunities. Defendant Casey made her false statements for commercial gain to eliminate her competitor, plaintiff Propson. Now, I think that's a stretch. I don't think that's why she made the claim. I don't think it was to get rid of Lauren the Mortician, but, go off, I guess. Defendant Day has publicly stated that plaintiff Braun uses unethical tactics to scare creators off social media platforms, explicitly attacking Braun's professional integrity and ethics as an attorney. Furthermore, Defendant Day's allegation that Braun committed perjury implied criminal behavior, which under Illinois law is considered defamation per se, due to the serious nature of the accusation and its impact on the professional reputation. In addition to Day's statement, defendant Vasquez and Martin made similar defamatory remarks. They publicly claimed that plaintiff Braun files false copyright strikes and is an unethical attorney, further compounding the harm to Braun's professional reputation. These statements were disseminated through podcasts and various social media channels, reaching a wide audience and causing significant professional and personal harm to plaintiff Braun. Plaintiff Probson's claim focused on defendant KC, who accused her of being a trans exclusionary radical feminist, also known as a TERF, and published statements suggesting that Probson endorses transphobic content. These allegations were made without basis and were intended to damage Probson's reputation among her followers and potential business partners. The resulting backlash included online harassment and loss of sponsorship, severely impacting her professional standing and financial interests. Plaintiff argued that these defamatory statements not only injured their reputations, but also led to a substantial economic loss. Plaintiff Braun experienced a loss of clients. Okay. And potential clients, and plaintiff Probson lost a significant contract with a well-known travel documentary channel due to defendant's false accusation. Can you prove that though? But I digress. The claims of defamation per se and trade libel under Illinois law and Wisconsin law and false light under Illinois law form the core of plaintiff's legal action against defendants. This memorandum is submitted in opposition of defendant's motion to dismiss and to strike under anti-SLAPP statutes, asserting that plaintiff have adequately stated claims for defamation per se, false light, trade libel, tortious interference of contract, tortious interference with existing and prospective business relationships, and intentional infliction of emotional distress. Plaintiff further contend that defendant's statement were made with actual malice and reckless disregard for the truth, warranting denial of the defendant's motion and continuation of the litigation to address the substantial harm suffered. While I was skimming this, I didn't it came to mind, but it didn't come to mind of, the more that I read this, the more I'm kind of wondering why these lawsuits are even filed together in themselves. They're suing under two different states of law, right? It almost seems like they should have filed their own lawsuits. Like Lauren the Mortician's case is literally only against Kitty. Her suit is not even against the other three defendants. So it's almost like Lauren the Mortician should have filed her own lawsuit in Wisconsin and not in freaking Illinois. And then Jeanette Braun could have filed her lawsuit in Illinois against all of the defendants because she's the one that has a problem with everybody. And again, the statements that are made, it's not like they're like arguing vicarious liability or they knew it was false because they had some type of cahoots with the other person. To me, it's not making sense that these are all filed together. It's just like we're all on TikTok, so we're just going to file this as a TikTok lawsuit. And I'm wondering if the court is going to try to divide them out. And maybe they won't, because it does seem like they all have the same attorney. So maybe they won't divide it out. But to me, it doesn't make sense that the lawsuits are filed together. And I don't do civil, so I could be wrong. But these don't seem like they are properly joined, in my opinion. But they also have not objected to being joined. So the court probably won't sparse it out themselves if the defendants never objected to it, saying this is improper joining of the cases. I think it is. I think it causes for too much confusion. And I didn't realize that until I'm reading this monster cluster F of a motion to get rid of the motions to strike and motion to dismiss against all defendants and this and that and all of the things. Okay. Anyways, we are on a standard motion to dismiss for failure to state a claim. And then also they are trying to overcome the anti-SLAPP rules. They go on to say, okay, we'll get into that in a minute. Okay, so failure to state a claim, the court has to view the facts most favorable to the plaintiffs, and they're not supposed to be trying to adjudicate the different facts. And what Lauren, the mortician, and Jeanette Braun is going to argue is that this case is, or the motions to dismiss and the motions to strike are trying to actually dispute the facts, not necessarily saying that it was a failure to state a claim. And then also that the anti-SLAPP also has to go under the test of failure to state a claim, because they are still talking about facts, not just the principle of the law of the things that are going on. And we'll get into why they're saying some of those things a little later on. Was there anything else in this legal standard part of it? Also, they're arguing an improper venue for Lauren the mortician, and I believe, I want to say in Kitty. I can't remember exactly. Yeah, because that's the only person she's suing is Kitty. And like I said, I don't think that Lauren the mortician should have filed this lawsuit. So, maybe that is that issue then. I don't think Lauren the mortician should be a plaintiff in this lawsuit. You got us going under Wisconsin law, and it's not like they said Jeanette Braun and Lauren the mortician are TERFs. They didn't do that. Jeanette is suing Kitty for a different reason than Lauren is suing Kitty for. And so I don't think that they should be tied together. Can each of them go and testify on behalf of each other in their own trials? I think, yeah, they can, but I don't see why they are actually filed together. It's not arising out of the same facts, in my opinion. Y'all can let me know if y'all think differently about it. I don't think they arise out of the same fact. The only reason why they're related is because Jeanette Braun is Lauren the mortician's attorney. So there's that. Okay, so we're going to get into the argument. Defendant KC, Vasquez, and Martin anti-SLAPP should be reviewed under the 12B6 standard because, let's see where we're at. Defendants California and Georgia anti-SLAPP arguments should be reviewed under a 12B6 standard because they challenge the legal sufficiency of plaintiff's claim. Let's see. Here, defendants all argue that plaintiff have failed to identify verifiable falsehoods within defendant's statement that are not protected by free speech. In addition, defendants each discuss plaintiff's pleading to argue that plaintiff have failed to allege sufficient facts to show the falsity of the defendant's statement. For defendant KC, the anti-SLAPP defense challenges the legal sufficiency of the amended complaint. They're going under 12B6, and this is regarding Lauren the mortician being a TERF and her having receipts and the deeds, okay? And so these are the statements that they're talking about. Oops, I'm not sharing the screen. That would be helpful. These are the statements that they're talking about as far as, Kitty trying to say that there's no falsity to the statements that actually were made. So failure to state a claim. So nowhere in the amended this is Kitty saying this, nowhere in the amended complaint does plaintiff Propson identify any statements from the October 24, 2023 TikTok post that Propson is transphobic or that KC has proof that Propson is transphobic. The other statement is, nowhere in the amended complaint do plaintiff allege that Propson has not liked these posts or followed these individuals on social media. Nowhere in the amended complaint do plaintiffs allege that KC has misstated what these posts say. Rather than the amended complaint alleges only that upon information and belief, none of the videos defendant KC linked contain transphobic or hateful rhetoric. Again, that's going to be opinion. We talked about this before. Moreover, nowhere in the amended complaint do plaintiffs allege any facts demonstrating that any statement made by KC in the October 24, 2023 TikTok posts are false. Rather, the amended complaint alleges only that KC was aware that Propson followed and liked pro-LGBTQ and pro-trans rights content on social media, and that KC chose to highlight only Propson's interaction with the conservative social media personalities. Okay. Again, this argument does not make a lot of sense to me, and it could be just because I'm not in this area of law. They're basically saying, okay, we need to go to under 12B6 for failure to state a claim because the anti-SLAPP statute, whether it's under free speech or not. I haven't seen this argument made in all of the defamation lawsuits that we have covered under California and New York law. I'm not seeing this argument made. So it's just not making any sense to me, maybe because it's my first time seeing it. So the falsity and the truthfulness of it, I guess, because in order to be I mean, it's part of the defamation of whether it's true or false, not failure to state. Well, I guess because they're questioning whether the statement is actually true or false, but also failed to state a claim because you did not state those claims. You did not state that she doesn't like transphobic things. You did not state that she doesn't follow these accounts. So they're bringing it up, but in a weird way for me. I don't know if y'all feel the same way, but it's making me confused. Okay. In addition, defendant Casey argues that plaintiff Braun failed to allege sufficient facts to establish that Casey knowingly made the verifiable false statements that plaintiff Braun files false copyright claims with social media platforms and a bad faith copyright strike against Casey. In essence, defendant Casey argues that plaintiff Braun's allegations regarding defendant Casey's statements that plaintiff Braun filed a frivolous copyright strike against her do not state a sufficient claim for defamation. Again, a bunch of words jumbled together that don't make sense to me. It don't make sense to me. Defendant Vasquez and Martin's anti-SLAPP arguments challenge the legal sufficiency of the amended complaint. Again, we're under 12b6, and they're arguing whether these statements were false or not. And this is the statements from Martin and Vasquez's motion to strike that they're saying kind of goes against the motion to 12b6. The amended complaint does not identify what false information defendants allegedly relied on, nor does it identify any alleged defamatory statement made by defendants in its alleged December 2nd, 2023 episode. The amended complaint does not identify any of these details discussed by defendants were false, instead identifying only a statement by Vasquez that social media content creators had informed her that they had received a false copyright strike from one of Braun's clients. And again, that's not them saying that the copyright strike was false, but it's them saying someone told me that they received a false copyright strike from Braun. In addition, defendant Vasquez and defendant Martin both raised general arguments claiming that plaintiff Braun and Braun Law failed to allege sufficient facts to show that statements made by defendant Vasquez and Martin are verifiably false. Here, defendants present anti-SLAPP motion to strike that are combined with motions to dismiss and challenge the legal sufficiency of plaintiff's claim. Due to this, Rule 12b6 analysis should be applied in reviewing the plaintiff's amendment. I'm confused. I might just be confused myself. Because they're doing a motion to strike for anti-SLAPP, but they're all also doing a motion to dismiss. I think OKC did a motion to strike, actually. So I don't get the point of this analysis. Maybe it's just to confuse everybody, and maybe the court will just be on their side. Let me know. Okay. This court should deny defendants' anti-SLAPP arguments that are based on the contested facts that are outside of the complaint. Much of defendants' anti-SLAPP analysis involve factual disputes that require discovery. In cases where defendants make anti-SLAPP motions to strike founded or purely legal arguments, and then the analysis is made under Federal Rule 8 or 12 standards that plaintiffs are not required to present a prima facie case or evidence supporting plaintiff's claim. Noting that the Ninth Circuit has clarified that anti-SLAPP motions are evaluated under different standards depending on the basis of the motion. The primary thrust of defendants' anti-SLAPP arguments is that they are protected under the First Amendment because plaintiffs are public figures and that plaintiffs' defamatory statements were made in response to the ongoing controversy. To support both arguments, the defendants raised disputed facts that are outside the amended complaint and not appropriate for a motion to dismiss. As a result, defendant motions should be reviewed under a 12b6 standard. That does make sense that if you're saying that the complaint fails to state a claim, you can't then start pulling out other things. I'm saying they didn't say the claim because what they're saying is false, or they didn't they're not telling the truth because this is why she actually said it. She left out the actual context. That doesn't go into the motion for failure to state a claim. For anti-SLAPP, on the other hand, you can talk about it being a matter of public a matter of public concern, which we saw done in the Lizzo case as well. So I don't like the argument is kind of right, but not really. What they're doing is they're trying to mix in the anti-SLAPP and the 12B all at one time. I just haven't seen that done before, so maybe it's me, and I'm sorry if I'm confusing other people, but I've never seen it done before where they're mixing the 12B6 along with the anti-SLAPP instead of looking at them separately. And they're saying the way that it's pled, it has to be put together. Never seen it before. It could be something new and fancy under Illinois law. I don't know. Let's go ahead and jump back into it. Defendant Casey's anti-SLAPP arguments against plaintiff Probson. To argue that her statement about plaintiff Probson was about a matter of public concern, defendant Casey argues Probson allegedly maintains a famous social media persona with millions of followers on TikTok, as well as sponsorships and a brand partnership with a famous documentary channel. Thus, she certainly is in the public eye. The parties are in dispute over whether plaintiff Probson is a limited purpose public figure and whether all aspects of her life are in the public eye. That's not at issue. That's not at issue. You filed a complaint making your client a public figure. That is not at issue. And the whole time that we've been covering this case, I have never seen the terms put together, limited purpose public figure. This is the first time that this is coming up. Not that I've never heard of it before, but this is the first time that it's coming up in this case that I've seen. And I think we've covered most of the major complaints in this, or major motions in this lawsuit. So whether she is a limited purpose public figure or whether she is just in the public eye, that's not at issue. They're just saying she put herself in public. She's on TikTok. She has a personality. She has 2 million followers. She's a public persona. You don't then get to go in and say, well, but is she a limited purpose public? No. You can't just bring that up right now. Just like you don't want them bringing up your stuff right now. You can't just bring that in. And it's never been brought up before. Okay. Casey's statement allegedly were made as a result of confusion between these two social media personas, Casey and Probson, by social media followers. Plaintiffs dispute, duh, you don't agree. Plaintiffs dispute defendant Casey's unsupported claim that fans of either party were confused that plaintiff Probson's Lauren the Mortician persona was defendant Casey's caffeinated persona, or caffeinated kitty persona. You're disputing the facts for failure to state a claim, but she is arguing under anti-SLAPP. Maybe I need to do more research. Because those are two different legal theories. I don't get how they're combining them together. Those are two different legal theories, but they're trying to mix them together. I would love to see how the judge rules on this, because I don't think this goes together. And again, don't quote me on it, y'all, because I do not practice this type of law. But I don't think these go together. And we've covered enough defamation lawsuits on this channel, and I've never seen this be a thing. So let's go on. You're allowed to say why, I am making this statement as my own public figure self to basically save myself from Lauren the Mortician effing up my bag. I think you can do that. Thus, the public issue implicated by Casey's alleged statement is the confusion by potentially hundreds of thousands to millions of individuals between two social media personas who are undoubtedly in the public eye, one of which has a liked and followed post containing transphobic and hateful rhetoric. The above argument relies on disputed facts because plaintiffs have alleged that the posts referenced by defendant Casey do not contain transphobic or hateful rhetoric. What? Why are you what? I don't see how they tied that together. She didn't want to confuse people and saying that what's her name liked the hateful rhetoric, but this is disputed facts. This is disputed facts because we don't agree that it was transphobic or hateful rhetoric. Those don't go together. These don't go together. I see what they're trying to muddy the water. That's all I can get out of this. This is just trying to muddy the water at this point, because those don't even go together. Okay, defendant Casey's argument against plaintiff Probson rely on contested factual assertions that extend beyond the scope of the amended complaint. She can defend herself. Okay? These disputed facts cannot be resolved at the state. We're not resolving the disputed facts. We're resolving whether it is the claim was stated, right? We're doing anti-SLAPP, which requires the person to be, they're two different analyses. Like you cannot convince me that you can combine these two analyses at this point. Two different analyses. Anti-SLAPP, a person of public concern regarding something of public interest, right? And then you go into whether it was true or not and blah, blah, blah. So she's able to bring up, okay, this is not true, it's not defamation because of these reasons. But for you to say it's a failure to state a claim it's a failure to state a claim under anti-SLAPP because we are disputing over the actual facts, we're not resolving the facts here. We're trying to figure out, is this a public concern, a public persona addressing a public concern? A failure to state a claim. Was defamation done? Is this a false statement? Those are two different, just because you're saying that it's not a false statement and they're saying that you're saying that it is a false statement and they're saying that it's not a false statement. That's not what we're resolving in a failure to state a claim motion. That's not what we're resolving. We're saying, did you plead facts to say that it was wrong? They said you claim that she called you a TERF, but at no time did you say that I am not a TERF and I did not like those posts. But somehow you guys are trying to tie it together and say, well, is she a public person? Maybe she's not, but also she's saying that it's not false. And we're saying that it is false. So there's no way the court can resolve this. That's not how it works. That's not how it works. I'm sorry, y'all, that I'm yelling into the microphone, but I'm really confused about where they're going with this. These disputed facts cannot be resolved at this stage and necessitate further discovery. No, it doesn't. The court can decide whether this is opinion. They can decide whether being a TERF is an opinion. Okay? You do not have to resolve whether it's true or fact. You do not have to resolve whether it is if she's telling the truth or you're telling the truth. You just have to determine, is this a fact or is this opinion or speculation? If it's an opinion or speculation, you can't go forward because there's no defamation claim. Okay, the central contention is whether plaintiff Probson is a limited. No, it's not. The central contention is whether plaintiff Probson is a limited purpose public figure and if her social media activities place all aspects of her life in the public eye. They're trying to be like, Casey, this is essentially what they're arguing. They're essentially arguing Casey saw Probson. This is my speculation story. It's probably not going to be good because, I come up with bad examples, but this is basically what I'm getting from this. Casey saw Lauren in her house picking her nose. Let's say that was the situation. And then Casey came on and said, I am not Lauren Probson because Lauren Probson picks her nose. See, look at this picture. Now that might be a stretch. That might be her public life because she's in her house, she's picking her nose. Leave her alone, right? But to say that she is on her platforms, her public platforms, which she is a influencer on, whether that be Instagram or TikTok, and she's liking transphobic stuff that everybody can see because you have a public account, that is still in the public eye. We're not talking about things that she does in her room with the door closed. We're talking about stuff that she's still doing in the public. So what do you mean is every aspect of her life in the public eye? No, but the things that she does on social media is in the public eye because she put herself out there. This is not making sense to me. This is not making sense to me. And maybe that's why I was so confused reading this earlier, because it just doesn't make sense. Is she a limited purpose public figure? Even if we find that she is a limited purpose public figure, which we've never talked about in this case before, even if we find this, right? Her liking transphobic stuff on the internet on her public page is in the public eye still. Maybe, just maybe, if she was on her little Finsta, a fake private one, right? and she was liking that kind of stuff, maybe they can get away with this argument. But her liking this stuff on her public platform that people... Let's go on. We're going to be here all night if I got to yell at this paper any further. Moreover, defendant Casey's statements of social media followers' confusion and alleged transphobic and hateful content of posts are vigorously contested by plaintiffs. We don't care if you contest it. She is able to explain her side. She can explain her side. Since these issues involve substantial factual disputes, they are not appropriate for resolution in the anti-SLAPP motion. I skipped over the law. I would like to see, I didn't see it earlier when I was skimming, but maybe there is some type of law that they cited about there being a huge factual dispute. I don't think so. I don't think it's a huge factual dispute. We just got to figure out if this fact or opinion. It's defamation. Is it fact or opinion? Okay. Therefore, the court should deny plaintiff's anti-SLAPP motion as it is predicated on disputed facts requiring further discovery and is outside the pleading's four corners. The resolution of such factual disputes must await a more developed evidentiary record. They may not be all the way wrong about that, but I don't think that they're analyzing the things that they're trying to analyze correctly. I honestly just don't think that. Defendant Casey's anti-SLAPP arguments against Plaintiff Braun and Plaintiff Braun law to argue that her statement about Plaintiff Probson was about a matter of public concern. Defendant Casey argues the amended complaint demonstrates that Casey claimed that Braun's DMCA copyright strike/complaint was false because Casey believed her use of Probson's alleged copyrighted material constituted fair use. Again, Probson allegedly has millions of social media followers, thus whether she has hired an attorney to file meritless copyright strikes against content creators simply is a matter of public interest and concern. Plaintiff Braun's pleadings show that Meta agreed with the DMCA request and removed the infringing content, which creates a prima facie case that defendant Casey committed copyright infringement and is not protected by fair use. You just said earlier that you don't need a prima facie case. So now you're telling me you are having a prima facie case? Okay, I guess that is fine. Okay, Kimmy, I see your note in the back. Okay. Okay, well, whatever. Plaintiff's allegations establish that the resolution of this factual dispute should be resolved after the parties have an opportunity to engage in discovery. You're just trying to drag this out. Likewise, if Braun were taking it upon herself to file baseless DMCA strikes against content creators without even being hired to do so, it would also constitute a matter of public concern. The amended complaint allegations establish that defendant Casey was aware that Plaintiff Braun was Plaintiff Probson's lawyer and knowingly published the false accusation that Plaintiff Braun was not Lauren the Mortician's lawyer. She didn't say she was not your lawyer. She said if you are not her lawyer, in a letter that she wrote to you, and she just reposted a letter that, and it said if you're not her lawyer, you shouldn't be doing this. This is a joke. To the extent that defendant Casey is claiming that she did not know Plaintiff Braun was not Lauren the Mortician's attorney is a factual dispute, and that should be resolved on a motion of summary judgment. You just want to push it into discovery so that you can pay more attorney's fees? Is that what you want to do? The filing of the copyright strike under the DMCA constitute an official proceeding as it is expressly authorized by law. Defendant Casey's argument that a DMCA notice constitutes an official proceeding relies on underlying factual disputes that are not before the court. Y'all, I cannot with this. No court in federal or state court has ever found that a DMCA process constitutes an official proceeding for the purposes of anti-SLAPP. Both of defendant Casey's protected activity arguments against Plaintiff Braun rely on contested factual assertions and that extend beyond the scope of the amended complaint. These disputed facts cannot be resolved at this stage and necessitate further discovery. Defendant Casey's claims regarding the alleged falsity of Plaintiff Braun's DMCA copyright strike and the status of DMCA filings are official proceedings involve substantial factual disputes that require a more developed evidentiary record. Plaintiff Braun's pleadings contradict defendant Casey's claim that she received a bad faith or false copyright strike. Plaintiff Braun's pleadings assert that defendant Casey used Lauren the Mortician's content and Meta subsequently removed defendant Casey's account. This directly contradicts defendant Casey's claim of bad faith or false strike, copyright strike. Okay. I'm not going to read that no more. So, has no one ever heard of someone being arrested and they feel like they didn't do it? And they go, man, they arrested me for no reason. They said I didn't have my blinker on when I did have my blinker on. The light was just out or something like that, right? I did signal. I didn't fail to signal. Are we going to start saying that's defamation now because you don't agree with the ruling? Because we can talk to several YouTubers and be like, do you agree every time TMZ takes down your video when you use a still photo of a video that they have the copyright of? Do you agree with that? No, she's able to contest what you did in public. She doesn't have to file an objection to you. Meta literally, and like these platforms literally take it down without talking to you first. So the fact that Meta take it down or Twitter took it down or YouTube took it down does not mean that it was a valid DMCA takedown notice. Lauren, or whatever your name is, Jeanette, we just covered your own lawsuit and you argued that yourself. So now we're going to say that this person who doesn't have a legal background can't contest and say that this is an improper takedown notice like you just did in a previous lawsuit? Come on now. You clearly understand copyright. And your attorney should too, because you should be helping them out. But now you're telling me it's a proper DMCA takedown because Meta took it down, but when they took down your client's Etsy thing, that wasn't proper, but Etsy took it down. You can't then, you can, but you are able to contest whether it is proper or not. You may not agree with what Meta did, and I can tell you from experience, these platforms take things down without even talking to you first. So it does not necessarily mean that is a valid takedown just because the platform takes it down. And they'll have to have experts come and testify to that. So to say that she's saying something false because she didn't agree with the takedown, just like you didn't agree with the Etsy takedown from your plaintiff, are you now being defamatory against that other person that you got a settlement with? No, that's why you got a settlement with them. Sorry, y'all. I had a serious camera talking break. So let me go ahead. We're going to jump into Vasquez and Martin's anti-SLAPP. We still have so much to go, y'all, but I want to check out the chat and see what's going on there first. So... And I'm sorry, y'all. I'm like stuttering today because I think I'm anticipating this being a long stream and it's making me like rush. So I'm sorry about that. Can't even get my thoughts straight on this lawsuit. Okay, so let's see what the chat has to say so far. Phoenix Waller says, I think there were some stalker concerns with Kitty. I thought that was with the Vasquez. Vex Jenkins says, I recently watched Salty Bob's update about this lawsuit and I was not prepared to cry. Ginger is doing him so proud. May he rest in saltiness in peace. I don't think I'm familiar with that. Kimmy Locker says, Lauren and Jeanette were already able to find where Kitty lives without her name being public. So I understand why she'd want to keep the private regardless of whether there's a pre-existing threat. So that makes sense. I forgot about that. Phoenix Waller says to Kimmy Locker, was that before or after the DMCA though? I get fuzzy on the timeline. If after and she filed a counter DMCA, they would have had her info from that. I don't think so. I don't think you have to put all that information in when you're responding to a DMCA. Kimmy Locker says to Phoenix Waller, I think it was after the DMCA, but Kitty has a PO box and I'd imagine she would have used that. And I don't think you have to put all of that information on there. It's like literally online forms where you click a couple boxes and they take it down. It's not like a super, extravagant process where you have to give them all your information. They usually just contact you via email, right? Small says, isn't it legally advantageous for them to be considered private citizens instead of public figures? Doesn't that impact the threshold? Yes. So if they are regular people, then we are on a negligence standard. You knew or should have known, or you should have known that what you were saying was wrong. But with public figures, you have to show malicious. So you knew or you had a reckless disregard to whether it was true or false. So It's a lower standard if you are a regular person. Not to be that regular people are not cool, but public figures have a higher burden to satisfy. Kimmy Locker says to Smalls, it would be advantageous to be private citizens because the threshold is lower, but if they deny being a large public figure, that hurts their claim for damages. Yeah, because if you're just a regular person, are you really getting these travel documentary what do you call it? Deals that are going to pay you more? No, not if you're a public or not if you're a regular person, but a private citizen. But if you're a public figure, then yeah, those damages are going to be a lot higher, right? Just Me MD says, question. So if I'm deemed a public figure, then the rules of defamation are different. And if this is the case, why? Yes. So like I said, if you're a regular citizen, the standard is negligent. So you should have known that what you were saying is false, which is a lot easier to prove. Like, okay, well, if you would have really thought about it, you would have known that it was that it was true. But if you're talking about public figures, you have to prove maliciousness. And usually that requires showing that you knew or you had a reckless disregard, which intent is very, very, very hard to show in cases of like, you would have to show that, oh yeah, she researched this and saw that actually Lauren the Mortician is not a TERF, which again, I think that's all opinion based anyways. I don't think they're going to be able to prove that one. Let's say that one of them said that she had a bar complaint against her. They did research. They, had a letter from the bar association that said that no, she does not have any bar disciplinary actions, versus just being a random person on the internet saying, oh yeah, she got bar, or like what the Vasquez and Martin said, someone told me that she filed a false copyright strike against them, but there's no reason to think that that person is lying. Then, it'll be harder to prove on negligence versus, okay, well, you knew that person lies. I don't know if I'm explaining this right, but either way it goes, intent, if it's a public figure, you have to prove intent or knowledge. And then if it's a private citizen, it has to be negligent. I know I'm not good at making up examples on the spot. Phoenix Waller says, I guess it just depends on where she was in the process of treating her influence status as a business. She was already at 2 million followers, so she's pretty up there. Small says, my theory is that it's filed this way because it was meant to be a scare tactic, not an actual suit. It's a mess. This whole thing is a mess. Just Me MD says to Smalls, that would make sense at the same time. Seems a countersuit is appropriate with the false welfare checks, doxing, unnecessary hardships, and legal expenses. Like, you would think they would leave the girl alone because you've already put her through enough. Small says to Just Me MD, 100% agree. I'm low-key disappointed one hasn't already been filed. They have to get through this first, and they've already had to, raise the funds to even respond to these things. Kimmy Locker says to Smalls, it was definitely meant to be a scare tactic, the exact kind of anti-SLAPP, what anti-SLAPPs are made for, in my opinion. Exactly. Smalls says to Kimmy Locker, agree 100%. Vex Jenkins says, if this goes to trial, I hope the cease and desist letter Janet sent to Kitty makes an appearance. I wouldn't have believed a real lawyer wrote it either. Yeah, it will. It will. It's the basis of the complaint. Gabrielle Joy says, as Runkle says, the only reasonable for a joint attorney and client lawsuit is if they're in the same car on the way to court and they get hit by a car or something like that. Exactly. I don't think that the facts give rise to the same situation. I don't think that Lauren's complaint should be in this one for sure. Even if they keep all the defendants together for Jeanette Braun, I don't think Lauren the Mortician is the proper plaintiff in this lawsuit, but no one has really brought it all the way. I think, Kitty's the only one being sued by her. Just Me MD says, in my opinion, free speech is not free. It will cost you, whether bad publicity, legal fees, causes broken relationships, or job loss. Just my opinion. Better think before you speak or do. Is it worth it? And that's the thing about even us being on YouTube talking about these cases. You need insurance, you need all of the things in place to protect yourself, because sometimes we do get on here and we make opinions and speculations without saying this is my speculation right before it, and someone can get mad and say, you said this about me. It's like, no, I'm trying to explain a freaking lawsuit. Like, what are you talking about? But it's just putting yourself out there. You put yourself at risk of being accused of doing things even if you don't have any ill will. Phoenix Waller says, tell us who the famous documentary channel is already, Janet. Kimmy Lockett says, we need a spicy brie overlay. Has to. I'm like yelling at the screen. Just Me MD says, guess my adult ADHD kicked in because I'm at a loss over the necessity of this motion. It's a mess. The whole thing is a mess. I'm confused. It could, maybe I need to stop covering cases. But no, we covered plenty of cases in areas of law that I do not normally follow, and we can follow the lawsuit, right? I cannot follow this. Like, they're bringing up stuff that's not even planned, like the limited purpose public figure. Like, where did that come from? And even if it was limited purpose public figure, her liking stuff on her public Instagram account still counts as her public figureness. So what are you talking about? Like, it makes no sense. Kimmy Locker says, suggest me MD. It's procedural. Kitty and the girlies filed to have the lawsuit dismissed, so they have to argue that it's legit and should be allowed to move forward, especially because if it's dismissed under anti-SLAPP, they could be liable for attorney's fees. Yes, of course. And like I said, even the way that they're tying it together and saying that anti-SLAPP doesn't apply, they're doing it wrong, in my opinion. Again, don't quote me on it because I don't practice this all the time, but we have read several defamation lawsuits with anti-SLAPP, and the way that Kitty and them responded is the way that you respond. The way that they are now, Propson and Braun are responding is not anything like I've seen responded before. It's like, oh no, but it's also not false, but also anti-SLAPP, but also, failure to state a claim, but also I'm confused and I don't know why I'm here. And also I want to use 50 pages to try to confuse you, Judge. And I forgot to say, they moved for the motion to use more pages, but the judge strongly advised them or recommended, or whatever you want to call it, that they use less pages. And this is probably why, because this is a jumbled mess. I can't follow it. I don't think they could follow their own arguments. They couldn't even come back and correct the arguments, in my opinion. Like, they should have just responded to everyone individually, in my opinion. Phoenix Waller says, I mean, the amount of bad scams out there combined with Janet's use of language, who wouldn't question it? Agreed. Just Me MD says to John Smith, I thought she did that already, and this is painfully redundant. It's horrible. This is horrible. Okay. Kimmy Locker says to Just Me MD, oh, it's definitely redundant. It just hasn't technically been done in this form yet. It's a mess. Miss Frosty says, LOL, love spicy brie things. Kimmy Lockett says, also, if we're deciding DMCA validity by social media platforms taking down video, Instagram and TikTok still have it up. So that's 2 for 3. Yeah, exactly. And they filed it on every platform, if I'm not mistaken. So that was a good call, Kimmy. The Small says, okay, has anyone actually seen Janet's degree, license, proof of lawyership? How sure are we she's actually a barred attorney? People have looked it up. I haven't looked it up, but people have confirmed. So I'm going to go with her being a lawyer. Phoenix Waller says, a small, don't quote me, but I think Madcaster had it on a video once when he was discussing how Kitty could submit a complaint based on the wellness check. Yeah. Crystal Yo says, oh, I missed so much. I'm so lost. Even if you were here from the beginning, you would still be lost because this is a mess. He would still be lost. Small says to Crystal Yo, I'd catch you up, but this don't make sense. I'm not the right person for the job. Y'all, I'm on the internet reading this aloud and I'm struggling. So if you think I can't even explain it to you when I'm the lawyer on the channel. So do not feel bad if you don't understand what's going on, because I don't understand what's going on. We're all just here in a freaking Jeanette Braun, Lauren the Mortician, la la land in this complaint or this response to the motion to dismiss. I can't even speak straight. Like, I know a lot of streams I do stutter, but this time I'm like, I can't even get my thoughts across to explain concepts to people because I think they're just confusing me. I think they're unlawyering me. You know how we said, do we know her lawyership? I think I have lost my lawyership reading this. They have destroyed me and my ability to lawyer. Okay, let's jump back into it. Where's Bossy B at? Okay, let's try the Vasquez and Martin anti-SLAPP arguments. Let's see if she does not confuse us any further. So we got defendant Vasquez and defendant Martin anti-SLAPP arguments against plaintiff Braun and plaintiff Braun IP law. In the attempt to establish a matter of public concern, defendant Vasquez and Martin both rely on the following disputed facts and information outside of the complaint. Hold up, wait a minute. Let me see. Other part that we have to talk about, I have not seen a response to a complaint where it's a motion to dismiss, where the defendants do not bring in their own facts. You are able to defend yourself. And if you were not able to defend yourself, how could any motion to strike or dismiss go forward? Because when you're filing a motion to dismiss and a motion to strike, it is before an answer is filed. And even if the answer is filed, which it won't be because it's a motion to dismiss, the only facts at play are the plaintiff's facts. The defendants just deny things. They don't then establish facts for you. You don't even establish facts until you get to trial or you stipulate to it before a trial. So what are you talking about that these are disputed facts? Duh, they're disputed facts. You think they can't bring up their own facts to fight you? Like, no, you get to bring up your own arguments. This is you don't even establish facts until trial. What do we call complaints? Allegations of shade. Those are not facts. We are not disputing facts. We're disputing your allegation in shade. That's what we're disputing right now. Not facts. The facts are not going to be found for months and weeks and years potentially. So when you talk about these disputed facts, Mr. Lawyer or Miss Lawyer, whoever this person is, what is going on? Do we need to now question this person's law degree too? Or is it just Braun? Gosh darn it, this is making me so mad, y'all. Like, we're not even halfway through this. Defendant Vasquez, okay. So under both Georgia and California law, statements that Braun is engaging in unethical or harassing conduct is unquestionably a matter of public concern affecting a large group of individual social media content creators who might be targeted by Braun or who might be considering using Braun as a lawyer. Defendant's argument rests on an assumed fact that the information they received was in fact true and factual. Whether defendant Vasquez and Martin actually received messages and DMs from other content creators is a fact not within the complaint. Why would that be in the complaint? And involves hearsay statements and additional documents that are not presently before the court. Who's this lawyer? The amended complaint, they are focusing on all the wrong things. The amended complaint neglects to mention that the later on episode 97, defendants show a screenshot of an email they received from an individual named Christian, in which Kristen stated that she had posted videos depicting screenshots of text messages, conversations she had with Braun's client Dimps, after which Jeanette reported two of her videos for copyright. Defendant also showed a screenshot of an appeal that Christian filed, which indicated that the copyright violation was claimed by Jeanette Braun. Okay? The above statement references documents, additional videos, and information that are not before the court. They are saying their basis for making the statement. What are you talking about? Why would it be before the court? You guys are not even in discovery yet. Well, who is this lawyer? Further, the statement rests on underlying claims and hearsay from a witness. This is such a bad argument, y'all. This is a bad argument. Okay? And hearsay from witnesses that has not been deposed. You can depose them. There's nothing stopping you from doing that. We do not argue back. We do not argue back hearsay. And, we haven't been able to depose this person, so they can't put this in their response. We do not argue that. Never. Never. Do you know how many documents I get across my desk where Jolie's mama said that they did this and the kid said that and the mama said this and the grandma said that and the grandma is ugly? You know how many documents we get across our desk that say stuff like that? We don't even address it because the only time that things are going to come out as fact or valid testimony is in trial. The court goes through all that mumbo jumbo. We ignore all of that. What is the basis? They're focusing on all the wrong things, y'all. I'm getting mad. I don't even think I can finish this. No, not that I can even understand it, but I don't think I can finish it either. This statement also assumes that the alleged victim is telling the truth, which, again, if you want the negligence standard, they would be more able to prove that they didn't know because they thought this person was telling the truth. And the court found in her favor. Defendant's argument that this was proof to back up their opinions showed a reckless disregard for the truth and blind reliance on hearsay. Blind reliance on hearsay without any further investigation. Hearsay is for court. Hearsay is not like if my mom told me my dad said I was short. I cannot say, Mama, you know what? That's hearsay. I don't believe you. I'm going to go ask my dad himself if he think I'm short. Like, no. What are you talking about? What are you talking about? Oh, my gosh. Without further investigation. Okay. Further defendant's alteration to say videos above show defendant did not provide any information regarding this alleged information about the alleged copyright suit and are now characterizing this as videos for the purpose of their motion to dismiss. Defendants Vasquez and Martin's argument rely on disputed facts and third-party witness testimony and should thus be resolved after the parties had a chance to engage in discovery. No. Further defendants request to review defendant's entire 1.5 long. You already watched it. How did you not watch it and file this complaint? You telling me you didn't watch the whole thing? Are you telling me you're just relying on clips? Come on now. Further defendants request to review defendant's entire 1.5 hour long episode ignores the fact that the video references documents that have not been tendered to plaintiffs and involves witness testimony. They don't have to. You're not in discovery. They barely respond to you. And witness testimony that is not before the court. Defendant Vasquez and Martin arguments are a request for this court to accept their characterization of hearsay statements as true without the opportunity to take discovery or hear plaintiff's fact and argument. Thus, defendant Vasquez and Martin anti-SLAPP argument. I think this person is not smart. I think that's my conclusion here. Plaintiff stated a claim for defamation and defamation per se against defendant KC under Illinois and Wisconsin law. Plaintiff amended complaint alleges sufficient facts to, so now we're back on Kitty. We have not talked about Day. We talked about Martin and Vasquez a little bit, and now we're back on Kitty. Okay. Plaintiff's amended complaint alleges sufficient facts to establish defamation claim under Illinois law and Wisconsin law as alleged in the first amended complaint. Statements were made to the public forum are verifiable in nature, false, and have caused the online internet community to engage in a harassing campaign on behalf of defendants. Plaintiff, we're only talking about one defendant. We're talking about only KC. So why are we saying defendants? Plaintiff have also sufficiently alleged enough facts to show that that the context of defendants' defamatory statements were made solely for the commercial purpose of engaging with their fans and making social media content for monetary gain. I don't think that you've shown that. I think that they show that they don't want to be associated with you hooligans. I think that's what it showed. I don't think it showed they only did it for commercial purposes. You haven't even proved that they made money off of the video. You just see that they got 100,000 views. Who says that monetary money was even turned on that particular video? You don't even know. You haven't done your discovery yet. How would you know if you didn't do discovery yet? Plaintiff Probson has pled sufficient facts to establish a cause of action for defamation and defamation per se under Wisconsin law against defendant. Defendant Casey's statement that Plaintiff Probson is a TERF in a video and that was posted on social media was a verifiable false statement that constitutes defamation under Wisconsin law. To state a claim for defamation under Wisconsin law, a plaintiff must show it was spoken to someone other than the person being defamed. It's false, it's unprivileged, and tends to harm the defamed person's reputation so as to lower him to the estimation of the community or to deter third persons from associating or dealing with him. You still haven't overcome anti-SLAPP, in my opinion, so it could potentially be a privileged conversation, and you don't know if it's false. Because it's a freaking opinion. She's saying, oh my gosh, Lauren the Mortician is liking this type of content. In my opinion, she is a TERF. And this is why I think she's a TERF. And then she showed people why she thinks she's a freaking TERF. You cannot freaking, guys, I can't even get my brain together. You cannot prove why someone thinks that you're homophobic, just like you cannot prove why you think that someone's racist. She gave her reasons to why she thought you were a TERF, okay? Whether you like it or not. So suck it. Oh my gosh. You can't say suck it on the internet. Yes, you can. You can't say that. It's my channel. Okay, anyways, here we go. It is undisputed that Casey published her statement to the public and is not raising a claim for privilege aside from anti-SLAPP. And you still haven't overcome anti-SLAPP. So that is the privilege that is still pending. Okay, the context, I'm not going to read all of them. She's saying that the anti-SLAPP is not ripe for a motion to dismiss. I don't agree with that, but whatever. The context of the defendant Casey's statement show that she was calling plaintiff Probson transphobic and claiming that she had proof of this. You're right. She showed her liking the things. So, okay, do you give me anything else? Despite the clear context of her statement, defendant Casey argues that she did not call plaintiff Probson transphobic and merely expressed her opinion that plaintiff Probson is a TERF. Despite her claims that she did not say the exact same statement, Lauren the Mortician is transphobic and I have proof. The context of defendant Casey's entire video is intended to say that she has proof that Lauren the Mortician is transphobic. But did she say that? You're saying that, I mean, I guess you can do implication, but no, I don't think so. Context and to give words, the context and to give the words of the statement and any implications arising from them natural and obvious. Meaning, again, doesn't matter if she is showing you it's an opinion. Let's just get here. You're saying that it's a fact. It's not. It's not a fact. You actually skipped over the fact of trying to explain to us whether it's a fact or an opinion. You skipped that complete part. Unless I skipped it by skipping stuff because this is stupid. But I don't think they addressed whether it was a fact or an opinion. You're just saying that it's false. But this is an opinion statement. This is a speculation statement. You're speculating that she is a TERF because she follows these people and likes these posts. Okay, skipping that part. Calling plaintiff Probson a TERF is defamatory and caused members of the public to believe that she was transphobic. It meets the third element. What did I just do? Sorry, y'all. Defendant Casey's statement that Lauren the Mortician is a TERF is defamatory and meets the third element of plaintiff's defamation claim. The statement is defamatory if it tends to damage one's reputation in the community or to deter a person from associating with her. The term TERF is commonly accepted in feminist communities as a derogatory term to describe a woman as transphobic. In her motion to dismiss, defendant Casey similarly makes the argument TERF does not mean anything but fails to provide any other plain meaning that contradicts the definition provided by trusted online sources such as dictionary.com and Merriam-Webster. According to both sources, TERF means trans exclusionary radical feminist and is a disparaging term. As alleged in the amended complaint, is it disparaging? Is it disparaging though? I don't know about that. The context of the entire video shows that Casey used the term TERF to disparage and attack plaintiffs Probson's character and reputation. I can't wait till they bring up all the stuff that they were doing to incite this. Okay. To further show the harm of being called a TERF, plaintiff Probson's allegations established that defendant Casey's incited an online mob to harass her campaign and she basically lost her sponsorship. So many words to say so little of something. Defendant Casey's statement is not a mere expression of opinion. Okay, now they're addressing opinion. So I have to take it back. I yelled at the screen too early. Okay. So her statement is not a mere expression of opinion and is not a subject of any privilege or protection from the First Amendment. Again, you already talked about this earlier, but you're going to talk about it again. Defendant's statement is a mixed opinion. Oh, so it's a mixed opinion. So you admit that it's an opinion. Let's see how you try to wiggle your way out of that statement. That was not a good move, attorney. I'm sorry, it was not a good move. Defendant Casey's statement is a mixed opinion that combines an expression of her opinion with a statement of fact. It is well established that statements merely claimed to be opinions are not automatically granted protection under the First Amendment. Noting that communications are not made non-defamatory as a matter of law merely because they are a phrase of opinion, suspicion, or beliefs. But generally, the defamatory communication must be a statement of fact. An expression of opinion generally cannot be the basis of a defamation action. However, where the defamer departs from expressing pure opinion that communicates what the courts have described as mixed opinion, then liability may result. Mixed opinion is a communication which blends an expression of opinion with a statement of fact. This type of communication is actionable if it implies the assertion of undisclosed defamatory facts as a basis of opinion. Okay, and other courts claim that someone is a racist can be verifiable if the conduct is given enough y'all know what I mean, if it's specific enough. However, defendants did not merely accuse Overhill of being a racist in some abstract sense. The press released a certain language which expressly accuses it of engaging in racist firing and disclaims upon the desperate impact of firing have had on immigrant women. Here, defendant Casey did not simply call plaintiff Propson transphobic. She claimed that plaintiff Propson is transphobic and that she has proof. As the context of defendant Casey's statements show, Lauren the Mortician is a TERF. I have receipts, I have deeds, and you should just go ahead and take a seat. It's a mixed opinion. It sounds like a rap to me, but okay. Mixed opinion that incorporates the alleged fact that plaintiff Propson liked transphobic material. Furthermore, the statements that plaintiff Propson was actively liking incredibly transphobic and hateful rhetoric and content insinuates that plaintiff Propson endorsed and expressed transphobic rhetoric. Although defendant Casey cast her statement as opinion, she rests her entire assertion on verifiable claim that plaintiff Propson liked and engaged in transphobic content, which by claiming that she had links to the transphobic content and that plaintiff Propson liked. This is not an abstract statement of opinion that plaintiff Propson is transphobic, but a mixed opinion relying on verifiable falsehoods. As a result, defendant Casey's statements are not privileged nor protected by the First Amendment. Okay, I can agree with them on that for the mixed opinion. However, she still didn't say she didn't like the stuff. She did like it. She did do the thing. So, I mean, is it false? Okay. Defendant Casey's accusation that Lauren the Mortician is a false or is a TERF is defamation per se. Let's see. Under Wisconsin law, the distinction between defamation, which is actionable by itself or per se, and that which requires proof of special damages is not the same as distinction of language, which may be defamatory on its face or may convey a defamatory meaning only by reason of extrinsic circumstances. If the only possible meaning or meanings of the communication under the facts in this case is defamatory is applied, blah, blah, blah. Let's see. It ruined her reputation. TERF constitutes defamation per se. Under Wisconsin law, a statement is defamation per se if the defamatory nature is obvious and apparent. I don't think it's defamation per se, but go ahead. Such statements damage one's reputation in the community or deter others from associating with them. Defendant's Casey's statement caused reputational harm and loss of sponsorship. Okay, so they're basically still pleading defamation under defamation per se, essentially. Plaintiff Braun and Braun law have pled sufficient facts to establish a cause of action for defamation and defamation per se under the Illinois law. This is for the false copyright strikes. They're claiming that it's defamation per se because it's basically illegal to do false copyright strikes. Again, they're calling it mixed opinion, and then she's showing basically the letter that Casey wrote to them. Sorry, I'm skimming because it's too much. It's too much. Calling it a bad faith copyright strikes. Again, like Kimmy said, 2 out of the 3 platforms did not even delete it. So I don't think so. Let's see here. A lot of words. We're going to just skim through it. She wanted to pay for her legal expenses. Not a bad thing. And again, this is based on her saying, if you are not her lawyer, then you really shouldn't be doing copyright strikes on people that you don't represent. Again, it's if. So I don't think she said that she wasn't her lawyer. And she can still think that it's a false copyright strike. Like, we've already talked about that. I don't know. That's not a good argument to me, but nonetheless, she keeps it. Defendant KC's defamatory statements are mixed opinions that are verifiable and not subject to First Amendment protections under the qualified privilege protection. Defendant KC false statements against Plaintiff Braun are not entitled to qualified privilege because she knowingly published her false statement with the sole intention of casting Plaintiff Braun in a false light to encourage her fans to donate to her GoFundMe. The qualified privilege in Illinois defamation law is based on the policy of protecting honest communication or of misinformation in certain favored circumstances in order to facilitate availability of correct information. However, even if a privilege exists in a case, the defendant may not rely on the privilege if he abuses it. Noting that plaintiff claiming a defendant abused a qualified privilege must show a direct intention to injure another or a reckless disregard of the plaintiff's right and consequences that may result to plaintiff. Let's see, a qualified privilege can be exceeded and defeated in circumstances where defendant makes false statements with intent to injure with a reckless disregard for the truth. Okay, here Plaintiff Braun alleges enough facts to show that defendant Casey intended to harm Plaintiff Braun with her false statements and thus is not entitled to any qualified privilege, even if applicable. Further, Plaintiff Braun alleges that defendant Casey made her false claims to incite her fan base to casting Plaintiff Braun as a rogue attorney that filed a frivolous copyright strike without knowledge or consent of Lauren the Mortician. In addition, the false statement that Plaintiff Braun DMCA takedown request was a bad faith copyright infringement strike was done to incite the public into thinking that defendant Casey's free speech was wrongfully infringed. These false statements were knowingly made for monetary gain to injure Plaintiff Braun's reputation and to make the narrative favorable to defendant KC. Due to this, Plaintiff Braun has alleged enough facts to overcome. Again, I don't think she has. Kitty was very clear when she says, if that's not what it is, you shouldn't be doing it, and posted the thing. And then Miss Braun, if you forget, you responded talking about Attorney Braun to you and being very pompous. So she probably did think that she needed to defend herself against you in court or with a DMCA takedown notice so she can get her freaking account back. Like, she is also, a content creator and you are interfering with her ability to make money as well. So I don't feel bad for them. Plaintiff Braun states a claim for defamation per se against defendant, thus damages are assumed. Okay, if it's obvious and apparent on the face that it was damage her representation, that her as a lawyer is doing false copyright strikes, makes sense, but also I don't care anymore. I don't even care anymore. Okay, Plaintiff Braun and Braun lost a claim for defamation and defamation per se against Jessica Vasquez and Lily Martin under Illinois law. We'll go ahead and cover this and then we'll check out the chat and then we'll come back to the day claims. I didn't even get to that part when I was skimming, so I have no idea what they're going to say there. Okay. Plaintiff Braun and Braun law stated a claim for defamation and defamation per se against defendant Vasquez and Martin. Plaintiff Braun, let's see. They defamation per se under Illinois law. They're going for the false copyright strikes. Defendant accused Plaintiff Braun for filing false copyright strikes, implying that her actions were illegitimate and conducted in bad faith. For instance, defendant Vasquez stated, and as unhinged as Jeanette is, as unethical as Jeanette is, she is finding some success in her practice. This statement was made during a discussion about Plaintiff Braun's legal methods and insinuated that her success was built on unethical practices. I mean, are you reading this lawsuit? Unethical attorney. The repeated claims that Plaintiff Braun is an unethical attorney were made during discussions about her legal practices, suggesting she routinely engages in unethical conduct. These statements were made publicly in a podcast and on various social media platforms. Specifically, defendant Vasquez and Martin accused Plaintiff Braun of filing false copyright strikes and of being an unethical attorney in her December 2nd, 2023 podcast episode and various social media posts. Defendants also discussed Plaintiff Braun's representation of Caitlin Dempsey, alleging that Plaintiff Braun used unethical tactics to file false copyright strikes against smaller content creators, thus intimidating them and misusing the copyright strike system. Defendants allege that Plaintiff Braun commits perjury, accusing her of criminal behavior. Specifically, Defendant Martin referred to Plaintiff Braun client Caitlin Dempsey, after publishing their podcast, stated, "I gotta say, one of our biggest questions in all of this is, do we think Demps know her embarrassing excuse of a lawyer is using her name while actively committing perjury? Someone might want to tell her." Defendant Martin and Vasquez made unprivileged publication. They made it on YouTube. They made the statement on YouTube, Twitter, Spotify, and podcasts, and disseminated it to other platforms. Defendant Vasquez and Martin's statements are not entitled to First Amendment protection because they are verifiable falsehoods. Defendants accuse Plaintiff Braun of filing false copyright strikes, implying her actions are illegitimate and conducted in bad faith. These statements were verifiable because it can be determined whether the copyright strikes filed by Braun on behalf of her clients referenced in the defendant's videos were frivolous. Again, we talked about that. You can get pretty much anything taken down with a DMCA strike notice. As far as being unethical, they're basically saying that they could have checked the Illinois bar to see if she had any disciplinary actions, and then committing perjury. She's calling it criminal behavior, so they could have been able to prove that by, I guess, checking her criminal record to see if she had any perjury charges. Defendant Vasquez and Martin's statements are not entitled to a qualified privilege. See, damages are assumed because they're basically saying it's so outrageous of what they did that you can basically anticipate that it would damage her career. So to explain it further, the defendants accused Plaintiff Braun of filing false copyright strikes, implying that her actions were illegitimate and conducted in bad faith. That is basically against her professional responsibility. Same thing with the unethical attorney. She has to be ethical to be an attorney under their rules of professional conduct. And then also committing perjury is a class 3 felony in Illinois. So you're basically accusing her of doing a crime. So it should be considered defamation per se. Plaintiff Braun started, let me see here. And then, okay, this one goes into day. So let me go ahead and check out the chat, and then we'll come back to the nonsense. Can y'all tell I'm getting tired of this? It's long, it's boring, it's repetitive. Like, so sorry, y'all, on this long. I wish I could have summarized it better, but it's so much. It's so much. So let's go ahead and jump into the chat and see what the chat has to say. Small says, cracking up. We're all just here on the Bizarro Land lawsuit. Yes, that's what we're doing. Small says, not lost your lawyership. I lost it. Lost at sea. Kimmy Locker says, apparently lawsuits are for facts everybody agrees to. Yeah. In the complaint part of it. Yeah. Small says, so what are you talking about? Girl, they don't know. I don't know. Zoe B says these people are living in their own fairyland of facts, and you can only respond to them if you agree with their facts. That's where we are right now. Small says laughing my off, Bree is over it, and I'm done. Kimmy Locker says they're focusing on all the wrong things because they don't have anything right to focus on. I think this defamation per se section is not bad, but everything else sucks. Like, I think this is not horrible. Okay. They are admitting that, yes, it is probably opinion, but they added a little snaz in there and saying that it's mixed opinion, which potentially they can prove. But again, I still don't think that I still don't think that they stated a claim because they didn't say this. They didn't say this in the complaint. They're now arguing that it's mixed opinion. Okay. But in the complaint, they were saying, oh, it's the fact. That's a lie. Well, now you're changing up your story. So I don't think the defamation per se and this defamation section, I don't think this is horrible. But everything else before it, we're 20-something pages in, and we're now getting to something semi-decent of an argument. But all that other stuff made no sense at all. Zoe B says there is, in fact, no basis for any of this ridiculousness. Kimmy Lockett says, not suck it, I'm dying. Can you say that? No, I was like, suck it. No, can you say that? Yeah, I can say it. Crystal Yo says to Smalls, I'm lost. I keep gaming to handle stuff and I'm lost. I'll go back and watch the replay. I don't know what case we're even on. We're talking about Jeanette Braun and Lauren the Mortician lawsuit. It's literally the only case that we're covering, but it's just a mess. It's just a mess. Small says to Crystal Yost, okay, but don't be surprised of replaying. Does it help? Yeah, it won't. It won't help. It's the Jeanette Braun, Lauren the Mortician scare tactic turned lawsuit where the defendants called their bluff and they won't give up. And they just won't let it go. Kimmy Locker says to Crystal Yost and Smalls, yeah, nonsense will still be nonsense tomorrow. It's not going to make sense because I'm confused. Phoenix Waller says, at this point, the judge has to have the patient. Oh, the judge told them, please do not file a long motion. And they did it anyways. Oh, gosh. Kimmy Locker says to Phoenix Waller, the judge said in a minute order that they were strongly encouraged to file shorter briefs. So, yeah, it's horrible. It's horrible. Small says to Kimmy Locker, LOL, I love professional / corporate reads. Kimmy Locker says to Small, right? Judge Sass has become one of my favorite kinds. Best part of the cases at this point. Phoenix Waller says to Kimmy Locker, but isn't this the second amended? Like you gave them more than one shot at fixing this mess. This is a response to the motion to dismiss, but they are on their first amended complaint. Kimmy Lockett says it's the first amended complaint. Yes. And this is what we're reading is the response to basically dismiss the motion to dismiss and the motion to strike. Phoenix Waller says to Kimmy Locker, okay, my bad. For some reason, I thought it was the second. No, they're on the first amended complaint because it's been going on too long. Yeah. We've already had like, okay, well, are you guys in the right? The judge has been trying to get rid of them. They're like, okay, are you in the right jurisdiction for real? Okay. How come no one's moving to get rid of Lauren? Okay. Can you not file such a long brief? Okay. Like the judge is like trying. They're going to get fed up at some point. Small says it's absolutely not accepted as derogatory lies. I don't think it's derogatory either. Zoe B says yelling at the screen is deemed justified for this lawsuit. I'm gonna have a headache by the time I go to bed. Small says what Zoe said. Zoe B says the lawsuit has done more damage to all these people's reputation than anything alleged in the lawsuit, in my opinion. Like, well, actually, it's disputed facts, so you can't argue that. You can't dismiss it because we still have disputed facts. Guess what? On summary judgment, you're gonna have a disputed facts. What's the other one called during the trial? I can't think of what it's called. Directed verdict. You're still gonna have disputed facts. Every single step of the way, you're gonna have disputed facts. Okay, that's just how it works in a lawsuit. So yeah, there's that. Just Me MD says, unless I totally missed something, I still stand on this being a waste of time, money, and resources. I agree with John Smith, who has to foot the bill for this nonsense. Their lawyers, people are donating money to the defendants to pay for these. So fans, yeah, they're doing a bad job. Kimmy Locker says it's just me MD. I'm crossing my finger it gets dismissed on anti-SLAPP and Lauren / Jeanette have to foot the bill. And the thing is, like, they didn't even address anti-SLAPP appropriately. So I'm hoping so too, Kimmy. Zoe B says the only fan bases incited by any of this goofiness is the LawTube communities that are merely trying to make sense out of these disjointed arguments disguised as a lawsuit. It's horrible. It's horrible. I am like, this is the most confused I've ever been on a stream. And I have to try to make it make sense, and I'm not doing a good job. Katana says, I don't believe it's ethical for an attorney to call it, calling a false wellness check snaps to that. And that's going to come out. You are unethical. Like, come on, that's going to come out. Kimmy Locker says, Katana, right? I don't see how anybody could think a bogus wellness check is okay. I also don't understand how attorney-client privilege can be upheld about it since they filed this together. And yeah, that privilege is going to go out the window. It's not a smart move. The whole lawsuit sucks. Kimmy Locker says, I think it's unethical for Jeanette to have allowed that in to be compromised. Yeah, I agree. I agree because their attorney-client privilege is going to be breached. It's going to be breached in this lawsuit. Zoe B says, curious if the various platforms track people that submit frivolous copyright strikes and eventually end up ignoring their submissions as they are basically just a nuisance. No, I don't think they do, because it's very hard once they take something down to get it put back up. It's very hard. So no, they just take it all as legitimate, and basically, like, if you have the audacity to file the copyright strike, I think that the platforms just take it as, okay, if it bothered you that much, it must be legitimate. And again, the copyright strike that they're referring to for Kitty is Kitty screenshotting Lauren the Mortician's freaking comment section. Not even her whole video, the comment section is what they screenshotted. And then they're like, oh, copyright strike because they did a green screen that is like legitimately permitted on TikTok. Like literally what they allow for on there. Okay. So let's go ahead and jump into this information about Day, y'all. We still got several pages to go. So I'm hoping I could get my brain back together and trying to figure out what's actually going on here. Where are we at with our likes? We are at 34 likes. Our like goal for the stream is 50 likes. So if you haven't hit the like button, please do. It does help us out in the algorithm, gets us more friends, and we get to reach our like goal. So of course, if you haven't hit the like button, please do. Okay, all right, let's jump back into it. Plaintiff Braun and Braun Law stated the claim for defamation and defamation per se against defendant Day under Illinois law. The statements accusing Plaintiff Braun of unethical conduct and making false copyright strikes constitute defamation per se because they imply that Braun is an unethical lawyer who engages in frivolous and illegitimate practices. Defendant Day's publishing of the same false claims as KC that Plaintiff Braun files false copyright strikes and is an unethical attorney and is a rogue attorney are defamatory statements that were made with reckless disregard for the truth. Again, why are we arguing reckless disregard for the truth if you're not a public figure? You want to tell me that Jeanette Braun is less of a public figure or is more of a public figure than Lauren the Mortician? I think not. Okay, Defendant Day's statements regarding Plaintiff Braun and Braun's law. False copyright strikes. Defendant Day stated that Braun uses unethical tactics to scare creators off of the app and makes false copyright strikes for the unethical attorney. She says it's unethical, suggesting that she routinely engages in unethical conduct, that the Illinois Attorney Registration and Disciplinary Commission told her that they received multiple credible complaints about Jeanette Braun, and they have assigned multiple attorneys to investigate the matter. How are you going to prove that no one told her that on the phone? Defendant Day claimed that Plaintiff Braun was an unethical attorney in a since deleted TikTok story post. Specifically, Day states to her fans, why y'all stalking her like that? But I just wanted to make it very clear that my position is to ensure that there is no rogue attorney on this app. You just assume she's talking about her. Due to the number of videos Defendant Day was posting about Plaintiff Braun when she made the statement, Defendant Day's fans presumably knew Defendant Day was talking about Plaintiff Braun. Plaintiff Braun established the second element of Defendant Day because the defamatory statements were published widely and without privilege on TikTok. Defendant Day were verifiable mixed opinions. So again, they're no longer calling it just a false statement. They're now saying it is mixed opinion. Okay. So Defendant Day's statement that Braun uses unethical tactics to scare creators off the app and issues false copyright strikes are verifiable because it can be determined whether a copyright strike filed by Plaintiff Braun were frivolous or discussed above. Actually, no, I don't know of any way that you can look up copyright strikes filed online. I don't know of any way that you can do that. So I don't know. I don't agree that that's verifiable. I could be wrong. I could just not know, but I don't think you can look up copyright strikes. The claim that Plaintiff Braun is an unethical attorney, that the Illinois registered, they could have basically looked up whether there was any credible complaints that she's a rogue attorney. She just says that it's false. She doesn't say how she could have proved that it was verifiable or not. Defendant Day's statements are not entitled to a qualified privilege. Let's see, they made it knowingly. There's no qualified privilege. Defendant Day's statements are defamation per se because they imply that defendant is not ethical, is incompetent in her profession, so damages are assumed. yes, basically, if you say someone sucks as a lawyer, people are not going to want to work with that lawyer. So makes sense. Plaintiff Braun and Braun Law stated a claim for false light against defendant under the Illinois. Okay, I'm not going to go through false light. I think it's going to be the same thing. You're unethical. You're a rogue. I think it's going to be all the same thing, y'all. I'm sorry. I can't anymore. I cannot read this anymore. They got inflictional emotional distress. They lost contracts. They lost all the things. Okay. I'm done with them. Okay. I'm sorry to abruptly end it. They didn't say nothing. It's repetitive. There's really nothing to talk about on this case. I can't even get my brain together. I stuttered throughout this whole live stream. Like sometimes I'll have a live stream where I'll stutter a little bit and then it will be okay. But this whole live stream, I couldn't even wrap my brain around what I was reading. And this is stupid. And I think it's a stupid motion. Response to a motion, memorandum of points and authorities. I don't think you gave me any points or authorities here, okay? The only thing that made sense in this response was the fact that they are now calling it mixed opinion. I think that's the best thing that they could have done for themselves. And now they have to prove that it's verifiable and they provided the information to make it verifiable. I don't think that they can do it on a lot of the claims. Maybe on KC's saying, hey, look at this account where she's liking it. But again, it's still opinion just because KC thinks that it's not like that page says, I am a conservative, hate of the trans community. That account does not say that. So again, it's Kitty forming an opinion about this particular account and forming opinions about Lauren because she follows this particular account. I don't think they're going to be able to prove a lot of it. I think it was a smart move to stop just calling it a fact. I do think that, but I also think that the attorney dug themselves in a hole by admitting that it is mixed opinion. I think they're going to really, really, really regret that. So let me check out a couple more chats and then your girl's going to go to sleep and try to wrap my brain around life at this point because this really just bugged me. And I'll tell y'all, like I tried to read it before the stream. I'm reading it on the stream. I'm still confused on their position, okay? I am still confused. So let's see what the chat has to say. Let's get Bossy B in here. Okay, let's see. I think I might have skipped some. Okay, so John Smith says, oh, am I like super late? Oh no, here we are. John Smith says, let me pull this over here. John Smith says again, I keep losing the chat. That's just straight up allegation. It was in response to the litigation. I'm not sure that can be raised. Is it straight opinion? And I don't know exactly what you're referring to there. Okay. Let's see. Let me see, y'all. It was in the back channel. Where did it go? Oh, okay. Sorry, Don. Okay, let's see where we're at. Zoe B says the OnlyFans base is incited by any of this goofiness. I think I already read that one, huh? Okay. I think we're caught up on chats then, because I think I read all of those ones and John doesn't want to be read online. Kimmy says, do I think it'll be dismissed? I do. At least certain portions of it, I think should be dismissed. I don't think that she overcame anti-SLAPP, but honestly, I don't remember if all of them pled anti-SLAPP. Rebecca Day, I don't think pled anti-SLAPP at all. So I don't think hers will be dismissed on that. I do think that KC should be dismissed on anti-SLAPP because they didn't address it. They didn't even address why anti-SLAPP doesn't apply. They just said it can't apply because we have disputed facts. That's not anti-SLAPP. That it's just not anti-SLAPP, okay? You didn't even meet the first prong of it. Okay, you're moving on to the second prong of it, and even then, you're admitting that it's not even fact, it's mixed opinion, and you're already admitting that it's opinion, and you're not even arguing that it's not verified. Like, they made different arguments in different parts of the motion, but they didn't tie it all together of the statements that were on page 5 and the statement that was on page 20. You just said it was fact for the anti-SLAPP portion of it, but now you're saying that it's mixed opinion for the defamation part of it. So I do think that it will be dismissed for the anti-SLAPP for the people that pled it. And then I think that they can prevail on a motion to dismiss. As far as Lauren the Mortician goes, I just don't think she should even be in this court. So I don't know how that's going to work out because I'm not too sure. I don't remember if they specifically pleaded that they should not be in this court with Lauren the Mortician. I believe Casey did bring that up, but it was not really addressed in this motion unless I skipped it when I scrolled past it and said I'm not reading no more. But I don't think they really addressed it from what we covered today. Zoe B says, Bree, you're super trooper for hanging in as long as you could. Motion for relief from reading the redundant paragraphs that do nothing to provide clarity. Nothing. Absolutely nothing. I don't know what the purpose. That really could have been 15 pages to address all of them. Like the court said, please do not file a long one. Don't file a long brief. Please, please, please. They should have listened to the judge because that was horrible. That was absolutely horrible. Okay, that's all I have. I feel like I'm talking myself in circles because they talk me in circles and now I'm ready to go to bed. Thank you, everyone that joined the live stream. We did not reach our like goal for today, but that is okay. Oh, that was the wrong button. That's the one I was looking for. We did not reach a like goal, but that's okay. We are still doing great. We're having a wonderful channel. But I hope everyone has a good night, and hopefully this does not, ruin your sleep or your day. We do have more cases to cover on Thursday. We should be going over Beyonce's copyright lawsuit, which I think probably would have been a little bit cooler than this one after reading it. It was just so long. And then we also have Sean Kingston being sued for some fraud that he's been conducting. And apparently his mother has been arrested for it already. We haven't found the documents on that yet. And then, just other celebrity cases going on. I would like to see what the court decides on this Jeanette Braun and Lauren the Mortician situation, because this was just a mess. I didn't like it. I hope you guys at least enjoyed the stream in the chat, because I know this was not an easy document to get through. But anyways, thank you all for joining. I will see you all on the next live